This is Chapter 3, Interest in Real Estate. There are many types of interests in real estate, also known as estates or tenancies. These terms are interchangeable and refer to the extent of someone's claim to real estate. Interests in real estate will be part of one of the two major categories: freehold interests, which refer to ownership, and non-freehold interests, which refer to possessory rights that don't include ownership, usually a rental. Note, having an interest in real estate doesn't mean you own it. It simply means that you have some right to the property. Freeholds. Freehold interests confer ownership. There are a number of different types. Fee simple absolute. Fee simple absolute is the default type of ownership. It is also referred to as fee or fee simple indefeasible ownership. It is an interest in real estate that is not in any way limited, and it is inheritable. The owner is entitled to their entire bundle of rights to the property. These interests are intended to be indefinite and are only limited by public and private restrictions, for example, zoning and building codes. Okay. Fee simple defeasible. Unlike fee simple absolute, fee simple defeasible or qualified fee ownership is an interest in real estate that is limited in some way and can be lost if some limitation is violated or a condition is triggered. There are three forms of defeasible interests: fee simple determinable, which is automatically lost when a limitation is violated; fee simple subject to a condition subsequent, which is lost when legal action is brought pursuant to the violation of the limitation and returns the property to the original grantor; and fee simple subject to an executory limitation, which is basically the same as fee simple subject to a condition subsequent, except that the property would be transferred to a third party named by the grantor, rather than the original grantor themselves. Life estates. Life estates are freehold interests that only exist as long as the owner of the property, the life tenant, is alive. The life tenant's deed will state who receives the life estate, usually a remainder man, upon their death, in a habeam clause. There are several different types of life estates. Life estate in reservation. Life estate in reversion. A life estate where when the life tenant dies, legal ownership will transfer back to the original grantor. Life estate in remainder. A life estate where when the life tenant dies, the legal title will transfer to some third party originally named by the grantor. The third party is the remainder man. Per autre vie, Old French meaning for another's life. A life estate that is not based on the life tenant's term of life, but on some arbitrary third party's life named by the original grantor. Legal life estate. A life estate created by law, often in cases of dower rights, where a surviving husband or wife is granted a life estate for real property that was not willed to them, but that was owned by their spouse at their spouse's time of death. In many states, a surviving spouse is entitled to dower rights, up to a third interest in their deceased spouse's real estate, in lieu of what was left in the will. The right is in shote, or inactive, before the spouse's deceased. The right is in shote, or inactive, before the spouse's death. Dower rights have been abolished in Massachusetts, but still appear on the national section of the exam. Homestead, a legal life estate granted to the owners of a family home. It often provides protections from the forced sale of the home to satisfy debts up to a certain amount. Usually, you can only have one homestead at a time. A life tenant has a present interest to the real estate subject to the life estate, while the remainder man, or the grantor, in a life estate in reversion, holds a future interest. This means that the life tenant may not commit waste, cause the property to be damaged, legally compromised, or at risk of foreclosure, because it would compromise the remainder man's future interest. Otherwise, the life tenant may enjoy their full bundle of rights, less the right to devise the property, a transfer in will. This is why it's important to understand life estates. Life tenants can sell, rent, or otherwise dispose of the property as they see fit, but anything they do while alive is undone upon their death. As a result, a client would probably not want to buy or rent property subject to a life estate. Severalty. A freehold interest, ownership, held by only one person. Its root is severed, ownership. In severalty is the ownership of real estate severed from any co-owners. A freehold interest held by only one person. Its root is severed. Ownership in severalty is the ownership of real estate severed from any co-owners. Co-ownership. Co-ownership, or concurrent ownership, or co-tenancy, is any freehold interest ownership shared by two or more persons, including corporations. There are several types. Tenancy in common. Tenancy in common is the default form of co-ownership. Co-owners who purchase property without specifying a type of ownership own in common. Ownership interests may be equal or unequal, but all co-owners have an interest in the entire property that cannot be compromised. This type of co-ownership is inheritable. Joint tenancy. Joint tenancy is a type of co-ownership that must be chosen by all co-owners and specified in the deed. All owners must hold 4 unities to create a joint tenancy. The unity of possession. All have equal rights of possession. the unity of time. All purchase the property at the same time. The unity of interest. All have equal interests in the property. And the unity of title. All acquire in the same deed. Once a joint tenancy is created, it creates a right of survivorship. Survivorship means that if one of the co-owners die, their interest is divided among the surviving co-owners evenly. A joint tenancy is not therefore inheritable. If one of the joint tenants sells their portion of the property, that portion of the property is removed from the joint tenancy. A joint tenancy can be completely terminated by agreement, voluntary partition, court action, partition action, or the death of all joint tenants. If all joint tenants die except for one, the joint tenancy also ends, and the surviving owner owns it in severalty. Tenancy by the entirety. Tenancy by the entirety is joint tenancy for married couples. It works the same as joint tenancy, but includes the creditor protections, a limitation on forced sale of the property to satisfy the debts of one spouse only. Debts must be in the couple's name for the home to be sold, and an automatic homestead protection for $125,000 and the ability to file for $500,000 worth of protection in Massachusetts. If the couple divorces, it defaults back to a tenancy in common, unless the couple chooses otherwise. In separate property states, including Massachusetts, which is considered an equitable division state, tenants by the entirety may sell or divide separately, similar to joint tenants. In community property states, on the other hand, the property acquired during marriage cannot be sold or devised without the consent of both spouses, since it is treated as the property of both spouses, even if only one actually bought it. In a community property state, anything acquired during the marriage is typically considered equally owned by both spouses, regardless of who earned it. This means that when a marriage ends, the assets and debts are usually divided right down the middle. On the other hand, in a separate property state, anything owned before marriage or obtained individually during the marriage usually remains separate. In the case of a divorce, these separate assets usually stay with the person who originally owned them. In an equitable distribution state, such as Massachusetts, the court aims to divide the assets and debts fairly, considering various factors like each spouse's contributions, financial needs, and other circumstances. This doesn't always result in a 50-50 split, but rather a distribution that the court determines to be fair based on a specific situation. So, the main differences lie in how assets acquired during the marriage are treated. Community property states generally split them equally, but separate property states keep them separate. And equitable distribution states divide them fairly based on certain considerations. Condominiums. Condominiums are a way to subdivide the building into separate units, creating fee simple ownership of the individual units and shared ownership of the common areas, hallways, elevators, roof deck, etc., as tenants in common. Most states have condominium laws referred to as a horizontal property act. The condominium is created via a master deed, which describes how the building and its condominium or owners association, the building's governing body, will be set up. A declaration of trusts sets up a board of trustees to manage the condominium association. Bylaws of the association are the rules of the building. A building that is made into condominiums is also known as a condo conversion. Each individual condo owner owns their unit via a unit deed, along with a share of the common areas in proportion to their unit's fair market value. Owners are responsible for their proportionate share of common area expenses and pay them as monthly condo fees. Owners that fail to pay their condo fees are at risk of foreclosure. Failure to pay the fees can result in the condominium association placing a super priority lien for up to 6 months of unpaid fees against the unit. These fees run with the land, meaning they are responsible for the unit. Not the unit owner, and therefore are binding on subsequent property owners. Because of this, Massachusetts requires a 6D closing certificate for the sale of every condominium unit. This certificate establishes the status of the condo fees as of the date of the unit sold. Watch out for common problems with condo buildings: special assessments, extra condo fees charged to repair or upgrade the building, a lack of capital reserves, money held in a reserve fund account by the condo associations and investors to pay for improvements to a property, and low owner occupancy rates. Cooperatives. Cooperatives are another way of structuring co-ownership in an apartment building. In a cooperative, a company, usually an LLC, is formed for the limited purpose of providing houses to its shareholders. The people living in the building own stock or shares in the company, or stock certificates, which give them a right to a proprietary lease to their unit. They do not own their unit. Instead, they own the company that rents them their unit. This gives owners a significant amount of control over what goes on in the building at the cost of setting the same control to their neighbors. The cooperative will have a co-op board like a condominium board of trustees, and owners will pay monthly co-op fees for building expenses, similar to condo fees. Banks will typically accept stock in a cooperative as collateral for a loan. Because cooperatives are indirect ownership, the sale and purchase of cooperative units are subject to oversight and approval by the co-op board. It can be difficult to buy and sell co-op units because of this limitation. The property might also have debt in their name of the corporation itself, which must be paid on time, lest the corporation itself go into foreclosure. Cooperatives are typically created to permit their residents to limit unit ownership in some legally permissible way, since the co-op board must approve of the sale of co-op shares. This allows the creation of housing for a specific group of people, for example, artists-only housing. Any limitation on cooperative housing must be legal and comply with fair housing law. Trusts. Let's say you're a parent with a 5-year-old daughter. One day you wake up and for some strange reason, you decide that you want to give your daughter your house today. Aside from it being a silly idea, there's an obvious problem with your plan. You can't give your house to a 5-year-old. How will she pay the taxes, clean the gutters, and so on? She's 5. It won't work. A 5-year-old can't take care of a house. But you won't take no for an answer, so you head over to your attorney's office and present them with your conundrum. They offer you a solution. You could create a trust and put your house in a trust for the benefit of your daughter. Sounds good. But what's this trust thing? A trust is a special form of ownership that lets you assign property for somebody without giving it to them right away. To create a trust, the person setting up the trust, called the trustor, will hire a lawyer to draft a declaration of trust, which is a legal document that creates the trust. As part of the process, the trustor will name one or more trustees and beneficiaries of the trust and decide on the rules that will govern the trust. In our silly scenario above, the beneficiary of the trust would be your 5-year-old daughter, and the trustee would be someone that you trust, hence the name, to take care of the property on behalf of your child. The trustee will be tasked with administering the property in the trust for the benefit of the beneficiaries, benefit equaling beneficiary, and will have a legal obligation to act in the beneficiary's best interests. A trust will usually have rules about when a property is to be distributed from the trust. In our scenario, maybe your daughter will receive the title to the house when she turns 21. In the meantime, the trustee will hold the property subject to the terms of the trust. Why would somebody create a trust? A lot of reasons. A most common reason is to avoid probate, which is the process by which property is transferred after someone dies. Probate can be complicated and expensive, and is sometimes subject to dispute. A trust avoids the process of probate altogether. Any property in the trust is distributed automatically when something happens. For example, the trustor dying. You may encounter trusts when practicing real estate for this reason. It is not uncommon for the property to be held in trust for estate planning reasons. You won't need to do much about this as an agent. That's for lawyers to handle. But you should be aware of trusts in case you run into a deed that lists the owner as someone like the Joe Schmo Living Trust, dated September 15th, 2023. Some more details you should know about trusts for the exam. Trusts are generally created during a person's life, a living trust, or upon their death, a testamentary trust. A testamentary trust. Trusts that only hold real estate are called land trusts. Sometimes the beneficiary of a land trust is also the trustor, and the public record will not name the beneficiary and instead only names the trust, which creates anonymity. Land trusts are also often used for land conversion. Land trusts typically last for some limited period of time, for example, 25 years. Timeshares. A way of dividing time rather than space in a property. Timeshares or time sharing is a form of ownership where the owner only owns a specific part of the year in a fee simple, along with the shared interest in common areas. The owner pays maintenance fees for upkeep and maintenance of the unit year-round. Time sharing is also known as interval ownership, a prepaid vacation, or floating use period. Securities. Securities are investments for example, stocks and bonds. There are a number of different types of securities. Syndications are legal entities that invest in a single piece or pieces of real estate. They may take many forms: partnership, limited partnership, corporation, limited liability company, or LLC, etc., and provide a return on how a specific piece of real estate performs. Corporations are corporate persons under the law and can own real estate in severalty or in common with natural persons, actual humans. Investors in syndications can either be general partners or GPs, meaning those with management roles, or limited partners or LPs, passive investors who do not have a management role. Only general partners have full liability for the financial obligations of the partnership. Limited partners are only liable for their investment. Because limited partners are only liable for their investment, their tax deductions for losses in the syndication are also limited to their investment under the IRS at-risk limitation rule. This rule says that LPs cannot deduct a loss greater than their total investment amount on their taxes, even if the syndication lost more than that amount. In contrast to syndication, REITs, Real Estate Investment Trusts, REMIC, Real Estate Mortgage Investment Conduits, and REMTs, Real Estate Mortgage Trusts, are real estate investment vehicles. They allow indirect investment in either real estate itself, real estate loans, and provide a return that is based on the performance of the national real estate market or specific submarket. Why are we concerned with these investments? Because a person must have a securities license to market and sell interests in an investment vehicle like syndication. Your real estate license does not enable you to sell an investment to them. Federal and state laws regulate securities and their sale, most notably blue sky laws, which protect the public from fraud on a state-by-state basis through the Securities and Exchange Commission, which has largely preempted these laws. Non-freehold interests confer the possession and use of someone's real property without transferring ownership to them. For example, renting. In a rental, the lessor is the landlord and the lessee is the tenant. Lease holds tenancy for years, estate for years, or interests for years. A written conveyance of the possession of real estate for a period of time. It must be in writing and have an expiration date. Tenancy at will. A verbal or written right to possess property without any specified terms or stated interval. Either the lessee or the lessor may terminate the agreement at any time. In Massachusetts, the lessor or the lessee must give 30 days notice to vacate in order to terminate a tenancy at will. Periodic tenancy, tenancy from period to period. Like a tenancy at will, but with fixed intervals, for example, month to month. Parties may terminate at the end of the period. Tenancy at sufferance, a holdover tenancy when the tenant stays in the property past the lease's expiration without the lessor's permission. Since the lessee is a tenant at sufferance and not a trespasser, the lessor must evict the tenant to regain possession of the property. Remember, the terms estate, tenancy, and interest can be used interchangeably. The exam will use all three, and you should be able to recognize terms, regardless of which word is used. For example, you should know that tenancy in common and estate in common will mean the same thing. Okay. So that was Chapter 3, Interest in Real Estate.